Dear students, Namaskar. Last time I have discussed two important judgments. One was related to Article 21 and 22, that was D.K. Basu versus State of West Bengal, and another was the Pramati Educational and Cultural Trust versus Union of India. It was related to Article 21A of the Constitution. What I found in the last case related to Article 21, that was Pramati Educational and Cultural Trust versus Union of India, was not completely recorded. So that's why again today or in this video I'm going to discuss the crux of the case in brief, and later on I will discuss the remaining portion what yet to be discussed. Dear students, in this case, which was related to Article 21A, as we already discussed so many times, that Article 21A has been taking its birth in our Constitution because of the provision of Article 45 of the Constitution, which states that the state shall take all kind of efforts or endeavors to provide compulsory and free education to the children of the age 6 to 40. And in the light of that provision, the Supreme Court also, as we have discussed in so many times earlier also, under Article 29 and 30 also, that in one case it was the landmark decision. It was the decision or judgment of Unnikirsan versus State of Andhra Pradesh, in which the Supreme Court, in the light of Article 45, declared that the right to education is, under Article 45 is not a simple right, but it is to be taken as a fundamental rights for the citizen, and the state means that either the central legislature or the state legislature must initiate to enforce the provision of Article 45 of the Constitution. And in pursuant of this decision, and in pursuant of you could say Article 45 of the Constitution, it's the Parliament which amended the Constitution by 86th Constitutional Amendment 2002 and inserted Article 21A to the Constitution, which provides right to education, compulsory and free and compulsory education to the children of 6 to 14 years age. Now, the validity of this Article 21A was challenged in this case. It's the case of Pramati Educational and Cultural Trust versus Union of India. And here, the Supreme Court upheld the constitutionality or upheld the constitutional validity of the 21A, and Supreme Court also examined the question whether also examine the question whether Article 21A inserted by Constitutional Amendment in 2002 alter the basic structure of the Constitution or not. Before coming to the uh, provisions of Article 21A, I would like to share some facts that we discussed that Article 21A, which provides right to education and provides that state shall provide free and compulsory education to all the children of the age to 6 to 14, and in such manner as the state may by law, means that for the purpose of enforcement of 21A, it's the state which may enact the law as they thinks fit. And that's why, accordingly, in 2009, it's the parliament which passed one act, that was the uh, 2009 act enacted by the parliament for enforcement of free and compulsory education. And the validity of this act challenged in one case, it was the Society for Unaided Private Schools of Rajasthan versus Union of India. And this validity or this case was decided by the three judge bench of Supreme Court. It was Chief Justice S.H. Kapadia, Justice Swatantra Kumar, and Justice Radhakrishnan. And out of three, to hold to hold that the act is valid and apply to all government schools run by the central government or the state government or run by the local authorities, and aided private schools including minority aided private schools are also subject to this act or the provision of this act. And unaided non-minority schools not receiving any kind of aid are also subject to these provisions. However, two learned judges, despite of the opinion of the majority of the two learned judges, the uh, the the two learned judges held that Act 2009 infringed the fundamental rights of the unaided minority schools under Article 30, Clause 1 of the Constitution. Therefore, this Act shall not be applied to unaided minority schools because that infringe the provision of Article 30 of the Constitution. And it was one Justice Radhakrishnan, uh, who differed with the two brothers judges' opinion and held that Article 21A of Constitution casts an obligation or cast and duty on state and not on the unaided non-minority private schools and unaided minority schools to provide free and compulsory education to the children from the age 6 to 14. And after the judgments of these judgments, that if the judgments of Society for Unaided Private Schools of Rajasthan versus Union of India. Then this Act of 2009 was amended by Amendment Act of 2012. And now the provision of Act 2009 subject to Article 29 and 30 of the Constitution. And here the one senior counsel learned senior counsel Mr. Rotegi for petitioners, he submitted that Article 21A creates a duty or casts a duty uh, on the state and its instrumentalities under Article 12 of the Constitution, and, and not cast any duty on unaided private educational institutions, and also submitted that opinion of Justice Radhakrishnan in unaided private schools of Rajasthan's case was correct, and so the duty cannot be imposed on unaided private education institution because it will infringe Article 19 Clause 1 Clause G of the Constitution, and that will also alter the basic structure of the Constitution because fundamental rights are to be declared as the basic structure of the Constitution. And here another learned senior counsel or senior learned counsel, Mr. Nariman, who also submitted for the petitioners and held that and submitted that Article 21A casts duty on the state as under the definition of Article 12. As all of you know, what Article 12 states, it defines the word state or the definition of state. And you know, the Parliament of India, Government of India, legislature of state and government of each state, local authorities and other authorities are to be covered under the ambit of Article 12 of the Constitution. And he also cited one Supreme Court decision or one Supreme Court ruling held in one P.D. Shyam Dasani versus Central Bank of India in 1952, where the language of Article 19 Clause 1 Clause F, which was meant for right to property, are available against the state only, not against the private individual. Means that agent, when we talk about any kind of right, it was the assertion from Mr. Nariman that agent, when we talk about any kind of the right to enforcement of rights, then all those are available against the states, not against the private individual. And he also cited another Supreme Court decision or ruling of Supreme Court. It was the decision of Vidya Verma versus Shiv Narayan Verma of 1952 that fundamental rights or fundamental rights of personal liberty under Article 21 is available against the states, not against the private individual. So therefore, the word state in Article 21, the word state in under Article 21A, which provides for right to education, would not include unaided private educational institution or private individual. And he also cited that Article 25 had the provision of free and compulsory education by the state, and by Article 21A, by Article 21A, which inserted in place of Article 45, and which was inserted for Article 45, and Article 45 was deleted by 86th Constitutional Amendment, and means that it was replaced for uh, 21A. So under Article 21A, the duty could not be passed on by the states to the unaided private schools. So it is confined to the state only and cannot be imposed to unaided private school, because it would again infringe Article 19 clause 1 clause G of the Constitution, and 2009 Act, or Act 2009, was enacted to pursue Article 21A, and uh, did not make any reference of Article 15 clause 5, which was inserted because of the 93rd Constitutional Amendment of Constitution. And all of you know that why 93rd Constitutional Amendment was inserted, or introduced, or why 15 clause 5 was inserted in Constitution, which talks about the reservation in private educational institution, aided or unaided, other than minority education institution. And here, what was the argument that this Act of 2009 was enacted to pursue Article 21A and did not make any reference of Article 15 clause 5. So validity of 2009 could be tested in the light of Article 21A and not in the light of Article 15 clause 5. And so accordingly, we can say the both Mr. Rohtgi and Mr. Nariman, both insofar 2009 Act, it relates to uh, unaided private schools or private education institution, that completely violation to Article 19 clause 1 clause G, and also and also interpreted in TMA Pi landmark decision, which was the decision of the 11 judges bench, and that it is a landmark decision, although and that the subsequent the interpretation of TMA Pi was done in one case, it was the Islamic Academic Foundation case. So here, what was the argument of the two learned counsel, that even it has been prohibited in TMA Pi case as per the interpretation of TMA Pi case. And another learned counsel for the learned counsel for petitioners minority education institutions submitted that subsection 4 of section 1 of 2009 Act should be declared ultra vires, as it violates Article 30 clause 1. And in replies to the argument or the statements given by the learned counsels for petitioners, it was Mr. K.V. Vishwanathan, Additional Solicitor General, he argued, he submitted that Article 21A was added for achieving goals and objective of Article 45 of the Constitution under directive principles or under Part 4th of the Constitution, which could not achieved even after of 50 years of the enforcement or adoption of Constitution. Accordingly, 2009 Act was enacted for free and compulsory education. He also referred paragraph 53 of TMA5, in which Supreme Court itself held that unaided private educational institutions, they will make the admission of small percentage of the students of poorer, weaker, and backward section of the society. And so he argued that once it has been made the provisions for the little percentage or to the extent of 25 percentage of the 25 percentage of the total students in first class to even in the unaided private educational institutions is not going to violate Article 19 clause 1 clause G of the Constitution. And he also referred one another important ruling of the Supreme Court. It was the Venkataraman versus State of Madras, and it was the decision or ruling of 1958, where the Supreme Court stressed upon the harmonious construction. Means that as and when if there is any kind of conflict between the two sets of law, then it's the duty of the courts to put the conflict on harmonious construction or harmonious interpretation. And in case if we are going to put it on the harmonious construction in the light of means Article 19 clause 1 clause G is going to be 19 clause 1 clause G, which ensures for guarantee for fundamental rights for occupation and profession, and on other hand Article 21A, which talks for right to education, uh, free and compulsory education to the children of the age of 6 to 14. Then, then after, then we could say that the Article 21A could achieve its goals and objective in case courts are going to make a harmonious construction, and it was the submission of learned Additional Solicitor General of India, and he so after hearing the both sides, and as we have got discussed so many times that it was the fight, or it's the fight between originally between Article 45 contained under directive principles, and now Article 21A and Article 19 clause 1 clause G of the Constitution. And you know that prior to Article 21A, 19 clause 1 clause G was subject to Article 19 clause 6 of the Constitution. But now under Article 21A, so long made by state for the purpose of enforcement of free and compulsory education to the children of 6 to 14 years age, of poor, weaker, and backward section uh, with a small percentage in unaided private educational institution to achieve the goal of equality of opportunity and social justice. So, such a law would not be restricting right of unaided private education institution under Article 19 Clause 1 Clause G of the Constitution. So, under Article 30 Clause 1, the the court held that the minorities, whether religious minorities or the linguistic minorities, have a special constitutional right to establish and administer their educational institution of their own choice. And this court, means Supreme Court, repeatedly held that state has no power to interfere, only could make regulatory measures, and no power to force the uh, force the minority educational minority educational institution to give admission to the students from non-minority students. And moreover, the court has referred one landmark judgment. It was the Keshavananda Bharati versus State of Kerala, in which the majority judgment, headed by Chief Justice Sikri, who had even gone to extent of saying that Parliament can't exercise of its amending power to abrogate the rights of minority. So the Supreme Court held that, in our view, if 2009 Act applies to the aided minority education institution or unaided minority education institution, the right under Article 30 Clause 1 will be abrogated. So, the Act 2009 so far infringe Article 30 Clause 1 is ultra vires the Constitution, and the decision in unaided private schools of Rajasthan versus Union of India means that in that case, insofar as it holds that the that 2009 Act applies to the aided minority school, is not correct. It was not correct. And the Supreme Court also held that 93rd Constitutional Amendment, which inserted 15 Clause 5, or 86th Constitutional Amendment, which inserted Article 21A, do not alter the basic structure of the Constitution, and also hold that 2009 Act is not ultra vires to Article 19 Clause 1 Clause G of the Constitution. So, so it means that it is not going to alter the basic structure of the Constitution also. So, the Supreme Court, ultimately, we can say, the writ petition on behalf of minority aided schools, unaided schools, was allowed, or is allowed, where the writ petition on behalf of non-minority private unaided school, private unaided schools or education institutions were dismissed or are dismissed. So it's all regarding the Pramati case, which relates to Article 21A, which guarantee for right to education. Right to education or compulsory and free education to the children of the age of 6 to 40. So now I'm going to discuss another important provision of the Constitution which relates to Article 22, 23 and 24 of the Constitution. And it's the Article 23 and 24 constitutes a group under the head of the right against exploitation. The exploitation, what is exploitation? We can say that exploitation is opposed to the dignity of individuals proclaimed in the Constitution, proclaimed in the preamble of the Constitution, and to the provision of Article 39 and Article 39E and 39F of the Constitution. And its Article 39E, which states that to protect health and strength of the workers and tender age of the children, and to ensure that they are not forced by economic necessity to enter avocations unsuited to their age of strength. Whereas Article 39 clause F states that the children are given opportunities and facilities to develop in a healthy manner and in conditions of freedom and dignity, and that childhood and youth are protected against the exploitations and against the moral and material uh, abandonments. So you know that why this rights and this right has been uh, made in the light of the mandate of Constitution, which talks for the guarantee for the protection of the dignity, and in the light of the mandate of the provision of Article 39 E and F. Article 23 prohibits traffic in human beings, begar, and all other forms of forced labor, selling a human beings or pledging the services of human beings for a consideration, living on the earning of prostitutes are the example of trafficking. Begar was a peculiar Indian system. The government or the local jamidar used to requisition the person to carry a goods. You know that in case if you go back 100 years back, then there was the system of begar, that on the requisition of the big zamidar or on the requisition of the government, there was a system of begar, that the human being or the people from the lower strata, from the poor strata, they were asked to carry the goods of big officers like Tahsildar, Patwari, or revenue officers or other officer, police officers, as and when they had visited the rural area or visited the villages, and they were supposed to carry the goods without giving any payments, without giving any wages. So no remuneration was paid and forcing a person to work against his will without payment is a form of exploitation of the weaker section of the society. So, for punishing a person who violates this injunction of parliament, especially uh, it was one act was enacted by the parliament in 1956. It was the Immoral Trafficking Prevention Act 1956 and Bonded Labor System Abolition Act of 1950. Oh, sorry, 1976. So this article forbids a bonded labor. Bonded labor is a form of forced labor that is forbidden. And you know that in various cases, it's the Supreme Court which had also ruled that there is a uh, provision of uh, exploitation, provision of forced labor, or provision of begar, begar in the light of Article 23 of the Constitution. And that's why, in one case, it was the case of People's Union for Democratic Rights versus Union of India, and that case is popularly known as Asiad case. And in case, dear students, in case if you are able to recall, I have to discuss this case uh, under Article 21 of the Constitution, and again it also relates to Article 23 of the Constitution. And at that point of time, I have got also referred Article 23 of the Constitution. And in this case, the Supreme Court gave a wide interpretation, gave a wide meaning to the word force, means forced labor. The force is not mere a physical or legal force, but also arising from the compulsion of economic circumstances or economic necessities. So the person in want has no choice. He may be compelled to work for a wage less than the minimum. So he may even agree to pay a part of his wages to a middleman, and that is a forced labor. And here, in this very case, it's the Justice Bhagavati. Justice Bhagavati said that the word force must therefore be construed to include not only physical or legal force, but also force arising from the compulsion of the economic circumstances, which leaves no choice of alternative to the person in want and compels him to provide a labor or services even though the remuneration received for it is less than the minimum wages. And this thus a person who provides labor or service to uh, uh, um, another for remuneration less than minimum wages amounts to forced labor under Article 23 of the Constitution. So, in this instant case, it was held that the deduction of rupees 1 per worker per day by the Jamadars from the wages payable to workers employed by the contractor for Asiad projects in New Delhi, as a result of which the worker did not get the minimum wages of rupees 9 and 25 paisa per day, was violation of Article 23 of the Constitution, and the court directed the citizens guaranteed by Article 23 by uh, private individuals. And in another case, it was the Sanjit Roy versus State of Rajasthan. It has been held that the payment of wages lower than the minimum wages to the person employed on famine work or famine relief work is the violation of Article 23, whenever any labor or service is taken by the state from any person who is affected by drought and scarcity of food conditions, etc., the state cannot pay less wages than the minimum wage on the ground that it is given them to help to meet a famine situation or in the condition of scarcity of the food, or we can say in the light of the severe hunger. So the state cannot take advantage of their helplessness. In another case, Dina versus Union of India, it was held that the labor taken from prisoners without paying proper remuneration was a forced labor and a violation of Article 23 of the Constitution. And the prisoners are entitled to the payment of reasonable wages for work taken from them, and the court is under duty to enforce their claim. Here, I want to uh, inform that the case of Asiad case was decided by the Supreme Court in 1982, and Sanjit Roy case was decided in 83, and again Dina versus Union of India was decided in itself in 1983. And in these both cases, here was the application of the ratio of Asiad Asiad case, or the People's Union for Democratic Rights versus Union of India. And another important the case law which was related to Article 23 of the Constitution, it's the Bandhua Mukti Morcha versus Union of India. And here, uh, that once it was brought into the notice of Supreme Court, uh, addressed by a postcard, that there was a bonded labor in the stone quarry of at Faridabad, and the Supreme Court held that, and Supreme Court constituted a commission which was supposed to inquire the conditions or presence of bonded labor. And when the commission had submitted its report, the Supreme Court held that when an action is initiated in the court through the public interest litigation, because that postcard was treated as a public interest litigation, alleging that existence of bonded labor, the government should welcome it, as it may give the government an opportunity to examine whether bonded labor system exists, and as well as to take the appropriate steps to eradicate or to curb the menace of that system, or menace the evil of bonded labor. So this is the constitutional duty or constitutional paramount duty of the government under Article 23, which prohibits forced labor in any form. Article 23 has abolished the saying abolished the system of bonded labor, but unfortunately, no serious efforts was made to give effect to this article. So it was only in 1976 that Parliament enacted the Bonded Labor System Abolition Act 1976, and providing for the abolition of bonded labor system with a view to preventing the economic and physical exploitation of the weaker sections of the people. So you know that it is there are another cases also, and which are related to bonded labor. Now another uh, another we can say uh, cite the another article, Article 24, which talks about the provision of employment of children below the age of 14 in any factory, mine, other hazardous employment, and the Employment of Children Act 1938, the Child Labor Provision and Regulation Act 1986, the Factories Act 1948, the Mines Act 1953, and the similar other acts prohibit the employment of children below a certain age or age of below the age age of your uh, age of age of 40. And as Article 24 and the cases related to Article 24, which talks about the provision of employment of the uh, children below the age of 14. And that this article has been inserted in the light of Article 39, and that is why 39 of the Constitution imposes Article 39 imposes upon the state an obligation to ensure that health and strength, as I have got cited Article 39 E and F, provision of the 39 E and F. So it is the mandate of the provision of Article 39 E and F. And the case law, which was related to this important article, Article 24 of the Constitution. In one case, it was the case of People's Union of Democratic Rights versus Union of India. You know that we have got discussed this case also, we discussed in the light of Article 23 of the Constitution. And what was the opinion of the Supreme Court in the light of Article 24 of the Constitution, which talks about to prohibit the employment of the children below the age of 40. And here, in this case, in this Asiad case, it was contended that the Employment of Children Act 1938 means that what was the contention given by the government, given by the government, that under Employment of Children Act of 1938 was not applicable in case of the employment of the children in the construction work. Means that because Asiad case was related to the construction work of Asiad projects of Delhi, since construction industry was not a process specified in the schedule of Children Children Act of 1938. So the court rejected this contention and held that the construction work is a hazardous employment, and therefore under Article 24, no child below the age of 14 years can be employed in the construction work even if construction industry is not specified in the schedule to the Employment of Children Act of 1938. So, expressing concern about this set and deplorable uh, omission, again, it's the Justice Bhagavati advised the state government to take immediate steps for inclusion of construction work in the schedule of Act and ensure that the constitutional mandate of Article 24 is not violated in any part of the country. In another case, it was the case of laborers working on Slal Hydro project versus state of Jammu and Kashmir, and it was the case of 1984, and the court has reiterated the principle which was evolved in this Asiad case, that the construction work is a hazardous employment, and the children below the 14 cannot be employed in this work. And you know that it's the in pursuance of to the above decision or above decision to the above duty of employment of children act 1938, the child labor prohibition and regulation act was enacted in 1986, which have been enacted, and the employment of children act of 1938 prohibits the employment of children below 14 years in the railways and other means of transport. So the Factories Act, Mines Act, the Merchant Ship is the Merchant Shipping Act 1958, Motor Transport Workers Act 1961, the uh, Plantation Labor Act 1951, BD and Cigar Workers Condition of Employment Act of 1966, and the Apprentice Act of 1961 prohibit the employment of child below a certain age. And you know, in the light of another, in the light of Article 24, uh, in another important and landmark case law, which was related to one PIL. It was PIL was filed by one renowned advocate, and it was filed in MC Mehta versus State of Tamil Nadu. It was filed in 19. It was the decision of 1997. The Supreme Court has held that the children below the 14 years cannot be employed in any hazardous industry, mines, or other works, and has laid down exhaustive guidelines how the state authorities should protect the state authorities should protect economic, social, and humanitarian rights of the millions of the children working illegally in the public and private sectors. So the matter was brought before the Supreme Court by a public spirited lawyer, Mr. M.C. Mehta, by, by a way of public interest litigation under Article 32 of the Constitution. He told the court about the plight of the children engaged in Shivkasi cracker factories. Though the Constitution provides under Article 24 that the uh, uh, children should not be subjected to the exploitation, and the law prohibits employment of child labor, and it casts a duty on the state to endeavor to provide a free and compulsory education to them under Article 21A of the Constitution and uh, Constitution. Yet there are seven under not 21A, but 45 of the Constitution, and yet because this case was related to 1997, but Article 21A was inserted by Constitutional Amendment 2002. So the court court asked to implement the mandate of Article 45 of the Constitution, but yet there are 17 million children working in the organized sector as as estimated by the Planning Commission, despite the constitutional provisions and various legislative enactments passed by the passed by many states, which prohibit the employment of the child labor. The child labor, the child labor is a big problem and has remained unsolved. So you know that it is a very serious concern, and that's why the court directed setting up a child labor rehabilitation welfare fund and asked the offending employer to pay for each child a compensation of rupees 20,000 to be deposited in the fund, and suggested a number of measures to rehabilitate them in the phased manner. So you know that all these are very far-reaching and far-reaching judgments which has been delivered by the Supreme Court time to time with regards to Article 23 and 24. And thanks, students. It's all for today's discussion, which was related to your Pramati case as well as Article 23 and 24. Thank you.